Let's start. It is actually quite somehow crazy what I have been asked to do in 1.5 hours, let's say, with some questions to go through the EU asylum system, which obviously is not possible without looking also on the international legal framework as well, quickly at least. And then particularly also looking to a complete new, not new system, but actually quite new because it has never been employed before, the Ukrainian temporary protection system. So you will have to bear with me that this is going to be a run through to some extent through some legal issues, while I'm also don't want to be too legalized. So I want to bring you some very practical problems and issues, and I would like to also, if ever possible, to give at least to some of you the floor to share some of your experience, because I can imagine that some of you might have already worked in this area. I've seen from the chats in the last first lessons that at least some of you had already some answered questions for the others and things like this. So there is some knowledge out there which obviously would be sad not to use. So let me say that's a sort of premise. It will be sort of hard, also because I'm speaking to myself, which is also somehow a weird situation. So anyway, we will try. Let's jump into it quickly. What I'm going to do is I actually have thought of to do the class into three kind of ways. First will be a going through let's say the theoretical framework, what we have in terms of legal requirements on board when we talk about EU asylum system. It's going to be very general, but gives you hopefully a framework which at least places the different pieces that exists into a frame, and which then you can, and you have to research further if you work with it, and you have to go into deep when you work with it. But hopefully I can tip on some of those issues which might be interesting, and open up some interesting path for you, and giving you a sort of framework. I have to tell you that this is sort of I don't really like this so much, but that will be the framework which will be presented in a very positive way. That's what the law says. But at the same time, as you know, law is completely different in practice. So we will come in the second part of my talk a bit more into some very practical problems when we talk about the access to asylum law in Europe. And you will see a number of issues that have been raised by Carlo already in first class, but which obviously I would guess is, at least for those who are, let's say, more familiar with the issues already, is an activist already on the ground, you might have already faced some of those problems or some challenges already in your work. Last part will be dedicated to Ukraine and the temporary protection system. That is just a sort of implementation since 6 months. So it's quite new. It's quite old as a system, but it's quite new in terms of implementation. I will go through the system quickly, but also touching up some of the critical points that has emerged in this, let's say, critical, but also interesting points that might be interesting for the entire common European asylum system. So anyway, so these are kind of three parts, and I'm going to start quickly with this, hopefully not too boring part, which is the legal, let's say, framework. I hope very much, please highlight to me any questions that comes up directly. I'm happy to, I'm not seeing them, so potentially if you can highlight them to me, it would be good. If not, then we will take them up after each part, basically. Okay. Okay, let's start. First thing is, there is something which is, again, theory, but which hasn't sort of important, has some importance as well when we talk about activism, because a lot of researchers, but also activists, are claiming that a full right of asylum would comprise this kind of 5 different components. And this is nothing that I'm just, telling you, but it's something that has been since a very long time acclaimed by a lot of asylum scholars, but also by activists. So first part, and this is obviously the biggest issue, as soon as you're interested in the subject, is that the person is admitted to the territory. This is something which in our system in Europe, it's not accessible, it's not existing in real terms. There is a sort of right to a humanitarian visa. Sometimes even this right is accessed, so there is or admitted, but that's very rarely the case. As you know, most of the people that comes and wants to try to receive protection in Europe has to go irregularly through the external borders. So first point, you can cross already in Europe. Unfortunately, this part is not implemented. But that's part of the claim of a lot of scholars and activists. Second part is to allow the person to sojourn there, so have a permit for protection, to have this person refrain for any kind of expulsion or deportation, have this person who needs protection refrain from getting extradited to the country of origin, meaning that in terms of, for example, there might be some person that have been criminalized in the country of origin, and they, as soon as sent back to the let's say criminal procedures in this given country, he or she might be exposed to death penalty or torture or whatever. In this case, this person should not be extradited to this country. So it's different from the expelling. I just wanted to make this sure. Expelling is about a person who is irregular in the country and needs is returned to the home country because of the irregular status. Extraditing is a request by the home country for criminal charge to send this person. A classical case, for example, would be that Julian Assange is asked to be sent from the UK to the United States, for example. That's a classical case of extradition. To refrain from prosecuting, punishing, or otherwise restricting the person's liberty. So these are the 5 rights that actually would allow to say that's a full right of asylum. As you can see, that's a bit theory. In practice, unfortunately, this is not 100% implemented, especially in Europe. I give you a quick overview about what makes asylum law to some extent extremely interesting, because you can see it as an interesting academic experience if you want, but extremely complex in terms of legal implementation. Because what you have in basically in asylum law is an overlapping of 5 simultaneous and often overlapping legal regimes, which forms the entire, let's say, network of law in terms of international protection for asylum seekers and refugees. So what you have in the first place is the International Refugee Law. That's the most famous refugee convention of 1951, which is the outcome basically out of the World War II and the problematics of the the refugee movements and those times in Europe. It was limited in the first place only to European refugees, but it has been extended with the protocol. That's why it's always cited together of 1967 to a worldwide phenomenon. The second legal framework is the international human rights law. What you can have here is that you have a bunch of international conventions. The most famous might be the International Covenant for Civil and Political Rights, the ICCPR, or, for example, which is highly relevant in terms of migration as well, the United Nations Convention Against Torture or other cruel, inhuman, or degrading treatment or punishment, the UNCHA. And all those elements, there's a bunch of others. There's, for example, the United Convention for the Rights of the Children, and so on and so on. All this forms a legal framework for the international human rights law, which has in itself overlapping articles that might be applicable for migrant and refugee context, but is well overlapping with the entire asylum law as such. In Europe, and then here we're talking about Europe in a very wide sense, you do have also the European Convention of Human Rights with its protocols that applies to situation of migration and refugees and asylum. In particular, you will, I think, go through it in one of our other classes. Highly relevant in this context is Article 3. Article 3 is the obligation for states of the European Convention of Human Rights, member states to the obligation that states not produce any harm and torture and unhuman treatment to persons within their jurisdictions. And this is applicable in the same sense also for migrants, because in the fact of being expelled, for example, to another country where this person might be threatened by this country of origin, for example, or third country. So this is another element which is quite important. So you see already 3 international regimes are overlapping in this area. You have to know that the European Convention, you might, it's not something completely new for a lot of you, but the European Convention of Human Rights is applicable to a lot of countries in Europe. We have 46 countries now. Before it was Russia as well, so 47, but now 46 countries that are, let's say, legally obliged by the European Convention of Human Rights through the framework of the Council of Europe. So this is very important to know, and then we will come to it a bit more later. The Common European Asylum System, which is the entire European law, meaning taking almost all European Union countries, member states into the context. So this is a completely new and very important legal framework, which has a lot of implication to the last part, which is the national law, where you have constitutions, but also, of course, a lot of national law provisions. So I think that's quite important that you get this kind of point now here, is that you really have a diversity of legal frameworks. They are overlapping, and sometimes obviously have been also in a sort of contradiction sometimes. Okay, that's not working. Oh, next week. I will going through quickly the most important legal framework. I'm not going to all those frameworks, obviously, but the most important one on international level is the 51 Geneva Convention. I put here the definition what a refugee is. Most of you might know it. If it's the case, great, then you just get reminded what it means. But if not, that's something you have to know. If you work in this area, you really have to know this definition. That's part of, let's say, the minimum, even if you're not a lawyer, the minimum of knowledge that you have to have. So basically, this is what the definition looks like. As lawyers, we usually have this sort of tendency to take us to boxes where we can tick conditions, and that's why for lawyers, I would say the definition is not looking like this, it's more looking like this. Basically, a person who is a refugee is outside of his or her country of nationality and habitual residence. You can see it here as the first tick box. If the person is in Europe, coming from somewhere else, that's the box that you can tick, the condition fulfilled. Second is that this person has a well-founded fear of being persecuted because of his or her race, and then a full list of 5 criteria. Go to it a bit more and deeper: race, religion, nationality, membership of a particular social group, or political opinion. Sixth condition is not really written in, but it's given by interpretation from whoever. That might be the state or also other persons. And that's very, now 7 is very important, and is unable and unwilling to avail himself or herself to the protection of the country, or to return there for fear of persecution. And it is, and that's the part which is also not written, but it's the second, after the first article coming, the articles that describe potential exclusions from this protection. So let us go quickly again through the definition, which means, so the first is easy to understand, outside of, often very easy at least. Sometimes could be tricky, but but usually it should be quite easy to understand. The second part is the well-founded fear. Here becomes a bit more tricky. What does it mean, well-founded fear? Here you have 2 elements, which is one is based more on the well-founded, so that's something. There are criteria that show that you can, that you really have prosecuted somewhere, or there is a potential of persecution. So there are some proofs. That's an objective criteria. And then you have the fear, which open up the possibility for a subjective criteria as well. So the fear is the open up box, if you want, to situations where a person is has a well-founded situation, so proofs, but at the same time, it's also a fear, so it's a future element inside. Being persecuted, persecution is, it's quite hard to define quickly, but you can imagine it's something which happening where the person is followed up, tortured, persecuted psychologically, or there are a number of acts that could be included in this case. Discriminated to an amount that is up to persecution, is in prison or whatever. Because, and that's very important, there is a link that needs to be made of the persecution and the 5 grounds for persecution, which could be race, religion, nationality, membership of a particular social group, or political opinion. I will come to a bit more in deep in a second. Okay, I think the rest is quite clear, but this is that's something which I think you should really, I tell usually in my students needs to be woken up in the morning, in the middle of the morning, and needs to have this present, this definition. What is important to know, as I highlighted, is the linkage between the persecution and one of those social concepts is quite important. So race, nationality, religion, political opinion, or being part of a particular social group. These are, in fact, social concepts and are defined by the society as such. I'll give you an example. For example, what is included into religion, for example, is obviously part of the society's belief on religion. And of course, nowadays, at least in our sort of Western concept, it is clear that religion is one part, but also being an atheist, for example, is part of the protection of a non-belief, if you want, to some extent. So, but this is certainly something that has been created in the last years, and it's something that the society has evolved to. The same is true, for example, when you talk about members of a particular social group. What is included here is certainly something that is evolving. For example, years ago, you would not easily define a person who is prosecuted for the fact that he is homosexual as a person of a particular social group. That is now definitely something that is clearly admitted as a ground for prosecution that amounts to refugee protection. So that gives you some ideas that actually these are things that is evolving, but also is a part of the social concepts. Where you can find more information, that's, for example, a good book to look at. Obviously, it's not the only sort of influence, but this book is sort of considered to be as a sort of soft law already, because a lot of judges looking at it, lawyers looking at it. So if you need more information about different parts of prosecution, then the UNHCR handbook on the procedures and criteria is a very good handbook that gives you a lot of information about interpretation of the different items in the definition, but also about the determination process of refugee status. Quickly, I'm not going into this now quickly, but because I think it's we don't have so much time. You can look them up also in the handbook. You will see them in the slides. I will give them in the slides. But believe me, I think as soon as you get more, let's say, more examples, you will also see that it's actually tricky at times. To categorize what are the grounds of prosecution in your particular case. If you have, for example, a person in front of you from Syria, and this person, for example, is not willing to, classic example exists in real cases quite often, a man who wanted to not to serve to the army, you have to, so the Syrian army and of the regime, you would wonder what kind of prosecution that might be. Here, I think, for example, you could easily understand that if you read the handbook, that that falls a part of the political opinion. You express yourself by not serving for the army in the regime. A political statement, and if you prosecuted for this political statement to some extent, you are prosecuted for it. And often the prosecution is not happening because otherwise you would have been already taken away or in prison or something. So the proof is hard to find, but with all those elements, you can find more information and more examples in the UNHCR handbook. So please go read. Another word, I talked about this already, the prosecution. Obviously, there is a threshold that needs to be fulfilled. So it's not something that is, each kind of prosecution is included as sufficiently severe to amount of refugee protection. So there needs to be a sort of threshold to be met. You can have direct and indirect prosecution, as it might be obvious for you. I put it here also the definition. You can see it. You can also Google it. Godwin Jill has highly written about this. It's a very important book about refugee law. So if you're more interested, then you can look it up. I included this slide because I think it's important for everyone to recall that, and that includes lawyers, but also non-lawyers, that actually provide some legal support, some legal orientation, some legal information to asylum seekers. There's a number of issues that needs to be, and competence and skills that needs to be, let's say, be created, where you have to learn, teach yourself to get to be a competent, let's say, person in this field. There's a lot of soft skills that you need to develop, but there's also a lot of, and you know, for a lot of people that might be completely, you know, useless to say because you're aware about those things, but it's very important, especially for, let's say, lawyers who might be less open to those kind of things. Cultural sensitivity, the understanding what it means to be privileged. You know, you go home after maybe you have advised your asylum seeker and you don't know exactly what asylum seeker is going to. This kind of privilege, you have to be aware about this. You have to be conscious about some items about psychology, about trauma. If a person comes to you with a trauma and you investigate in a certain story, then of course you might reactivate a trauma, which is not helpful for the person in front of you, but it's certainly not helpful neither for the asylum claim as such, and so on and so on. So I think let's say this, I include this slide because I do believe that legal skills are very important in this area, because you have to know what is the protection, what is your law providing. You have to know how to navigate, let's say, practice of law as well. But you also have to have a number of skills that which are non-legal skills that actually helps you navigating. With all this kind of sets, you become a competent person to support people, but you have to be conscious that these have been developed at the same way as well to legal skills. Okay, one important part, and this is fundamental, I think Carlo touched upon it, is the so-called non-refoulement clause. That's something which is the cornerstone, let's say, of the refugee protection. Let's say what is important to know is that a person is per se, this is the understanding of refugee law, is per se not somebody who has to be declared by the public authorities as a refugee. Now, the refugee status is already somehow, and this is, let's say, scholarship on this issue, is that you have your refugee character already with you, you import it with you, and it is just the authority who recognize it. But this means that even before you are getting sort of formal recognition by a public authority, you should be protected. The protection is going beyond the recognition as such. And this is the so-called non-refoulement clause, which is contained in Article 33 of the Geneva Convention. And it's basically saying that the person should not be returned to a country where he or she faces serious threats to his or her life and freedom. This is very important, because even if you have not yet recognized refugee status, you cannot be returned. That makes you, as soon as you, basically, in basic speaking, is that as soon as a person comes into your country and raises a hand and says, "Oh, I'm asylum seeker, I need protection," or something like this, the state should, I know in practice that's different often, but should at this point consider this person as an asylum seeker, and has maybe not formally, but at least informally started an asylum procedure, and should, as in this case, not be sent back to any kind of country and I'm talking about any kind of country, not only the country of origin, but not even the country where this person might be facing a serious threat. So that's a very important part. And Article 3 of the European Convention of Human Rights is, let's say, the counterpart of the non-more clause in our European Convention of Human Rights system. Okay, the convention has other basic rights. This is just, I'm going very quickly, not be expelled, part of this first kind of 5 grounds, but you also have a number of rights that are related to social and economic rights that as soon as a person recognized as a refugee needs to have admitted to work, to housing, to education, and all this kind of stuff. Yeah, I'm not going into, you can read the convention, and I'm already a bit late. I think I'm just skipping this. The other main instruments coming now to the European asylum law, as mentioned, is the European Convention of Human Rights, including in the European law system, the Charter of Fundamental Rights of the European Union. You can see in Article 18 here, the right of asylum is guaranteed in conjunction, it's recording basically the Geneva Convention. So basically all this, what I have talked to you in the first 20 minutes now is exactly embedded into the European law system through the Charter of Fundamental Rights. And you can see it also in the Treaty of the Functioning of the European Union, where also it's in several references it's taken to the European to the Convention of to the Geneva Convention. Let's say in the 1990s, so in the 90s of the last century, the European system started to think about, first of all, because everything started with this kind of idea to have a freedom of movement of goods, services, but also persons. So the Schengen area has been created in '85 as a sort of wish and political wish. But as soon as they talked about the implementation of this political wish into practice, they thought, I cannot do the European harmonization on free movement of rights and abolishing of the internal borders without harmonizing at the same time the protection system on asylum, because there has been a lot of fear that that some countries will have to share the have to take up the burden of all the refugees, while the others are not doing anything under the asylum system. So there was a lot of push, mainly also from Germany at those times. You have to remember in the 90s, in the early 19s, the Balkan War brought 3.5 million of refugees to Germany at those times. And this really made a lot of political pressure for Germany at those times to handle the situation, but also to us, their counterparts in Europe, to step in to share the burden. That's why the common European asylum system has been sort of started to be created. So we're talking about really the early 90s when we talked about this issue. The most famous one we talk about on Wednesday is the sort of Dublin Convention, which was this cornerstone for Schengen, let's say, the Schengen area to be developed. So what does the common European asylum system, which has then been implemented in the early 2000s, what is the meaning of it? The first idea is to create a sort of standards, harmonization of standards of protection in all European states in terms of asylum law, and creating practical cooperation, and you can see increased solidarity and a sense of responsibility amongst EU states. As you can see, that's EU speech what I'm giving you here, in practice, you have seen, especially in the last years, a number of problems with this, ideals of the common European asylum system. I will go quickly what the European asylum system. This is a picture, which is obviously a very nice picture of. It's from the European Commission, by the way. That's if you can see, the Migration and Home Affairs Department has developed this. It's a very nice and smooth process. That's the imagination of asylum. You come to the door of the European Union. You ask, can I go in? I'm an asylum seeker, and I'm going through a smooth process where I do fingerprint and nicely speaking to other people, and then I'm admitted, or I say, oh no, I'm not admitted, I go out. That's a very nice picture of how the imagination of the asylum system is functioning. Obviously, in practice, most of you might know this is not how it works. But it gives you at least some ideas about what has been implemented in the middle. So there's a reception center in the first place. There are identifications. There is the interview and the assessment of the asylum system. And then there is the decision of the asylum a claim, which can be negative or positive. And depending on the outcome, you have some legal ways either to go and appeal and being admitted in the country, or you have to return to your home country. So that's the basic idea behind. So how it is implemented, you see a number of directives. Actually, what's funny is that when I prepared the slides, some of the slides I used in my classes on asylum law, I have actually in the last years taken away the temporary protection directive, which you can see in the first place. We will come to it when we talk about Ukraine. Because it was not used at all. You can see that it has been implemented in 2001. Basically in 2002, all member states have implemented this directive already, but it has never been used because you need a European and the Council of the European Union decision to enact the directive's goals, and this was never done. I will come to it later. In the second and the third part, let's say. There's another directive. It was also shown already by Carlo, and the reception conditions. So getting a minimum standards of reception and also the asylum procedure has been harmonized. I must say, this has been implemented not in 2013, as you see it here. This was the second generation of these documents already, has been implemented in 2003. As a first place documents, and I must say, for example, for Italy, this meant that the first time a real asylum law has been established. Before, it was not established in the same way as it is done afterwards. So it really helped also some countries to develop asylum law, which I think you can look as a good outcome in a certain way for those directives. In terms of legal assessment, so what is actually the protection scheme? You have so basically based on who is a refugee definition, which is very often very, very clearly linked to the refugee definition we have gone through in the very beginning. These all can be found in the directive, the so-called qualification directive on minimum standards for the qualification of the status of refugees or international protection. This is the directive, which is the basis of open up the refugee status determination and how you have to determine let's assess whether a person can be receive protection or whether not. There's another element, we come to it on Tuesday, so I will refer it to on Tuesday, the so-called Dublin regulation coming from the Dublin Convention. I will talk about this more clearly on Tuesday, but basically what you have to know is that It is only one single country in the European Union who is legally responsible for the asylum claim, and this is determined by the Dublin regulation. We will come to the criteria of this determination quite clearly on Tuesday, but what you all know potentially is that often the first country of entrance is the country responsible for the asylum claim. And all the other countries, if secondary movements of the migrants is happening, can then send back to the first country of entrance the person. But we come to it more in detail on Tuesday. So I skip this. What is important as last point on, let's say, to close the legal framework, the qualification directive has opened up not only for the definition of the classical refugee definition, which is quite a tight definition if you think about it. So it's not open up, for example, easily to protection of climate migrants, of people that have to flee for war, for example. So more generalized conflicts, because of the fact that the assessment has to be always individual. That's why, because we have also European Convention of Human Rights, Article 3, meaning that as soon as we have to return a person because they cannot provide them protection on an individual assessment on the refugee status, the European Union has enacted also the subsidiary protection, which is a new form introduced basically by the European legislator, based also on the judgments of the European Convention of Human Rights. This open up specifically for conflicts. So if a person would fear to be harmed in a way by returning back the person to the country of origin, or the country of origin, then subsidiary protection might be given. So it's a second part of protection. Sometimes in countries, in practice, that's exactly the same sort of protection that you get. In Italy, for example, you get a 5 years protection status as subsidiary protection, the same as a refugee status. In other countries, like Germany, for example, subsidiary protection is not given in the same way. So it's you get less years of protection. Just to give you some ideas about this. So that's just how it looks like. So as soon as a person fears serious harms, death penalty or execution, torture or inhuman treatments, we classical the article. So A is basically Article 2 of the European Convention of Human Rights. B is in particular Article 3. And 3C is what you often see when a war, internal armed conflict is produced. So here in Article 15 of the directive, of the qualification directive, you can see this kind of subsidiary protection, which is quite important and actually influenced a lot of people. Before going to access to asylum in Europe in a more practical sense, I wanted to open up if there are some questions, and potentially also thinking of if we make a small break or not. So let me just go quickly to so the book, you will see it, has been Kylie, I have seen you already as a very prominent, so you have a lot of knowledge already. Thanks for sharing the link. The question from Bari is if the asylum seeker has defected or for political reasons, and the politicians in this original country change, can he return to his country? Yeah, that's a good point. I think we would all claim that member states in particular would say that as soon as a person is not prosecuted anymore because of a change of government, dictatorship has been, taken away by a revolution or things like this, a person would need to go back to his home country, and the protection would end in the country of host. That might be different in a way as soon as a person has already stabilized in the country. So that might be also something that you might consider. So as soon as you, for example, live more than 5 years regularly in the country in Europe, you get a long-term resident status often as well. So you might have been integrated as such. Okay. So what else? So I think it's Nicole. You want to say something? Let me just quickly stop.
Can I open to her okay.
Yeah.
Yes, Nicole, you can speak right now.
Hello, can you hear me? Yes.
Yes.
So my question will be, as far as I know, there is a list of safe countries that, like the people who are handling the procedures of asylum, they had. So in the case of subsidiary protection, would it be also the case that if you are claiming that your country is in a war, or like there is like a civil war or a political conflict, then the country should also appear as an unsafe country in this list? You know what I mean? Like it's enough that I claim that it's a civil war, or my country or ex-country, whatever, should also be on this list of safe countries?
Yes. No, absolutely. If so, you're right. There's a list of safe countries. That basically means that a person, it's not implemented by a lot of member states, but some member states have implemented it. So if you, for example, coming from a certain country that is per se proclaimed safe, then the national authorities, that's particularly the case, for example, in Germany, can make the asylum procedure quicker. So they can, as if prima facie, they can basically say that the person has to be returned because it is a safe country and it's not. So it can be quickly dismissed, let's say, the application. You have the possibility, however, to make an appeal and to make a more particular investigation by the judges. But it is a sort of first kind of prima facie impression that this person is coming from a safe country. So in per se, I would say a country on a safe country list cannot be considered. So a country where a war conflict, for example, is there cannot be considered to be a safe country for sure. That's something which should not be happening. But you know, practice sometimes is difficult, and it's also a political question often. But I would say all those countries that are in safe lists in Europe, I would not say that they are that it's easy to claim subsidiary protection, I would say. Okay. So any other questions at the moment? Okay, I don't think so. So what I would propose is then we make a small break until 6:10, 8 minutes. Okay. Is good for you, or hope so.
Sorry, I was responding to Lydia on the chat. Probably Lydia want to speak, but she can raised her hand. No, Casey, hold on. Lydia, for instance. Casey, you have a question probably?
Okay.
I can understand if Casey Horo has a question.
Okay.
Okay, I think nobody have questions. Casey, if you have a question, you can speak, please.
Can you hear me?
Yes.
Yep.
Sorry, I'm at the airport, so I don't know if you can hear me well, but the example of a safe country, because we are talking about like sorry, my autocorrect corrected me 2 times, and I wanted to write Libya, safe country, which should be safe, but it's very questionable.
Which one? Which country? Libya?
Yeah, she say Libya probably.
Libya. Yeah.
No, Libya is not a safe country.
Sorry for the.
It's okay. Yeah, probably she's safe if Libya is a safe country.
No, it's not. It's actually also, you have to consider, I mean, there is a different way. You can say, for example, that some what we have to know is that to be put on a list, on the list of safe countries in a certain national system, let's say the European system allows people, the politicians, to put countries as on a list of countries which are safe, and sometimes it's happening. So Italy has done it, and Germany has done it. So they put a certain numbers of countries on a list. With those countries on the list, the situation is that as soon as a person comes from this country, let's say Albania, for example, in the case of Germany, if this person comes from this country, then the asylum application goes very quickly and smooth, because the authority will say, oh, you come from this country, that's why it's negative. You can still claim that this is not true because you have prosecuted individually. There might be reasons for it, but you have to, the threshold to prove it's higher, basically. And it's also, you basically often only in the appeal phase you come up with real questions. So only some countries that actually, I think in Germany is that has the issue is that as soon as it is lower than the recognition rate of asylum applications is lower than less than 5%. These countries can be actually admitted as a safe country, politically on the list. Libya is certainly not one of those, and none of the European countries has ever considered Libya as a safe country. That's for sure. I hope that answered your question. Yeah. Kylie said, of course, EU through Frontex funds Libyan. Yeah, sure, of course. I will come to it. It doesn't mean that we collaborate with Libya on asylum. So that's unfortunately that doesn't mean that we are not going into collaboration with different countries, but it doesn't mean neither that they are considered as the legally safe countries. Yes, Laura, that's absolutely true. It is a contradiction that it is just the idea of safe countries has been built up because you have to imagine it's a very practical argument, basically. No, you have all those people coming from a certain country, which are 95% get rejected for their asylum claims. Basically, the authorities say, okay, if you come from this country, there's a high chance that you get rejected. That's why they open up this kind of quick procedures for safe countries. And it doesn't mean, legally speaking, it doesn't mean that you don't have rights. You can still appeal against the decisions. But practically speaking, a lot of those rights are actually taken away because practically it's very hard to find a way to get it sometimes. So yeah, I absolutely agree with you. Tunisia, for example, for Italy is on a safe list. Big problem for a lot of activists because, and I will come to it when we talk in 2 minutes about the access to Europe and access to asylum and practice. Tunisia is a big question mark because a lot of those people from Tunisia are actually taken away. Yeah. Yeah, but Casey, Libya is not considered to be a safe country. So I think you have to differentiate what the legal speaking means to be on the list of countries safe lists, because it's had an implication for the asylum procedure as such, or whether cooperation with countries are continuing. And here, Europe often makes no difference with the persons, with the countries where they come from, what kind of country it is, whether it's in war or not in war, things like this. Yeah. Could you repeat again what you say about the lower rate? Yeah, it means that if you look at the statistics, you can see in different countries, and they vary between countries. That makes it also difficult. There's no clear saying about so all the Iraqis get protection in all countries more or less the same way. Now there are differences, huge difference between the EU countries. You can see this on the statistics. Go on the European Asylum Office or go agency, basically now it's European Asylum Agency, or go to Eurostat and you can find us. And so lower rates means that which in this different country, asylum claims from this country, so citizens from those countries are considered often negatively. So there's no asylum protection provided. Okay. Yeah, through Ukrainian, we come to it later, and I hope I almost answered all the questions in your break. I'm sorry, that break is over. Hope you're all with me now again. And we could come to more questions afterwards, okay?
Okay.
Let me, yep.
Yeah.
Okay, let me continue with my slides. So I promise to be a bit more practical now. Hopefully it was not too boring in the first place to have all this legal let's say framework. So I'm not sure. So yeah, I have opened my Q&A, but that doesn't show this in your. You can see the slides well, right? Can you? Okay.
Yes, sure. I can see.
Okay, cool. Thanks for thumbs. So access to asylum in Europe, that's a big issue in practice. In fact, what you can see here is some statistics these are classically the problematics. You can see that's in 2022. You can see that we have 107 per sea, a lot of people coming per sea to the countries like Italy, Greece, Bulgaria, Spain, but also some by land. And when we talk about land, it's actually through the Turkish border mainly. I can give you some other plans. This is, I think, in 2000. You can't see it. It's moving. No, this is 2022. Go. Yeah. Oh, sorry. Sorry. And this was just give you some ideas about how it looks like in 2016. You can see a lot more people have been, and the reason I can explain quickly afterwards as well. So when we talk about arrivals, these are all irregular arrivals. People that actually have to go through a very painful process to come to the European Union, crossing external borders. And this is what makes the access to Europe quite problematic and not easy. Now, as soon as they come and say, hey, I'm an asylum seeker, can you please give me asylum and protection? Those refugees are welcomed in Europe. This is the picture often that people see. So refugee welcome is something which is unfortunately a dream, not really a reality in our practical circumstances. What you have seen already is that a lot of people have to cross the borders through irregular means. And if you can see the policies here, that's the internal border in Ventimiglia. I will talk about this in a second as well. What has the European Union, let's say, responded to this problematic of a lot of death? This year in particular is a year where a lot of death has been produced. I think I have a slide afterwards where you can see some of those problematics. It has actually produced the so-called hotspot approach, which had two goals, basically, or let's say more than two goals. But first is the medical examination, especially in the pandemic, was quite featured as the most important thing to do. But at the same time, there was also the identification process that needs to be done from the perspective of the European Union. And there was a lot of problems in the beginning of the different refugee, let's say, waves that came from 2011, 2012, the Libyan war, then to the Syrian crisis in 2015, and so on and so on. Because some countries like Greece, like Italy, didn't really wanted to do the identification process well. So there was a lot of pressure by countries in the north to force the European countries in the south to process identification, and also to some extent try to, in a very unpleasant way, to identify whether it's an asylum seeker or a regular migrant. And what the problems are, it's quite evident. Some of those have been seen in the protests already. There's prison-like conditions, difficult conditions in these centers, often claimed as inhuman and degrading. And there is this kind of very problematic selections. I think you can see here the different hotspots that have been created. Famous names by now. You have heard of a lot of them. Let it be Lesbos, Chios, Samos, or let it be Lampedusa, Pozzallo, Trapani, Taranto. These are classical hotspots that are a lot of in media, but also in activists' minds because of the situations there. This is a picture showing you how they live. This is Lesbos. which obviously often have been overcrowded. Now Lesbos is not looking like this anymore. It has been like Samos, for example, highly secured centers. Here you can see some of those processes that actually happening in these centers, which are often, yeah, you could say, claim selection process, which obviously, so you have to imagine, you come up in the hotspot, especially in the last year in Italy under the Draghi government, but also in Greece under the center right-wing government. Hotspots have been becoming more and more closed centers, detention centers, basically. The idea is to force people to identify and at the same time also to select. So if you can identify persons coming from Tunisia, for example, and that's really happening in Lampedusa, let's say, they would be immediately taken away and considered prima facie as irregular migrants. If you not have at hand immediately proof that you are an asylum seeker, which prosecuted who are prosecuted in Tunisia, then you would be taken away from the hotspot directly to flight back to Tunis, basically. This kind of selection is quite, especially it was claimed in one of those questions, it's quite questionable because of the fact of the individual assessment obligation on refugee status assessment. The conditions are hard, as you can see, overcrowded. These are pictures from quite time ago already, but you know, the situations have not improved at all, and that's part of the big problems that countries are, especially on the front line in the south, are experiencing. So the European Union is forcing those countries to make the centers available with the new proposals on the border procedures. This will become more and more problematic. So the hotspot has been a sort of test case for the European Union to open up a more specific detention system on the external borders. Unfortunately, this needs to be said like this. I wanted to show you quickly how an asylum procedure would work in Italy, but I'm not so sure whether I have time to go through now. Potentially, I can come back to it if you want after we have spoken about Ukraine. I wanted to make another spotlight in practice. Problematic is very highly problematic is the cooperation with third countries that has been started by the European Union. So mainly there has been the wish to stop this kind of refugee flows coming to Europe. So before they actually come to Europe, before it is an issue for European countries. So they want to get cooperation so that people are stopped in these transit countries. And the other idea is that repatriation of rejected refugees should be enhanced. This is something which a lot of political discussions are going on with these kind of third countries. I give you some examples. Some of you know them certainly, like the EU-Turkey deal. That's potentially the first really big EU collaboration that has been enacted. So European-wide, although the Court of Justice in Luxembourg doesn't seem to say that it's a European decision, but in fact it was, that more than 6 billion of euros have been given to Turkey for Turkey to stop Syrian refugees, basically, or other refugees coming from other countries, to cross the border to the European Union. As you have heard a lot, if you go through Evros River situations and things like this, you can really see that Turkey has used it as a political tool. They open up to make a bit of pressure, and they close down again until as soon as an agreement has been reached. A number of those examples can be highlighted as well. Libya is one of those, have been discussed in the chat before, and one question was about this. Libya has received a lot of support, specifically to open up coast guards that would save lives in the Mediterranean Sea, those people that are coming through the border through boats. This is highly problematic, as you know, that a lot of, especially this year, a lot of this kind of pushbacks or let's say rescues from Libyan coast guards has taken people back to Libya and back to detention and torture it sometimes. Another example is Niger. Niger has played sort of the good, brave student for the European Union. A lot of money has been influenced in one of the most poorest country in the world, but not to develop the country further, but in terms of making security features available in Niger to close borders, which are basically borders to other African countries, and especially when Niger is part of the ECOWAS area. So there's a free movement area in the ECOWAS region, which is an older free movement area than our Schengen area. It has been enacted since 1979. A border which is basically never has really existed in real terms. There were some stones, but there was no fences or things like this. European Union at the moment starts to help Niger to control the border, build up fences, build up border controls, make satellite overseeing systems available, and all this kind of stuff. This is ongoing. Just in September, a Frontex agreement with Niger has been reached. So cooperation will ongo in this area, and the main outcome is that let's say on the publicity, refugees are less coming to Libya, so they cannot go through northwards. But this is what at least has been claimed to be observed. At the same time, refugees are taking other roads, bypassing this kind of roadblocks, so they might not be even recognized as counted for this kind of statistics. So I would claim that this just created a further problem to make people more moving in more dangerous routes. Anyway, I could talk ages about this kind of corporations. Unfortunately, it is something that is really happening. Externalization of borders is something which is a real problem. European management of migration has been externalized as a real political issue for the last good 5-7 years. And the effects is really working. The countries in the southern Saharian region are more and more cooperating and taking more and more a let's say security approach to migration, which is very harmful in my view. So anyway, I'll stop talking about. We can have discussions points if you want to talk about these issues. Yeah, here last slide about the different roads. You can see a lot of those roads have changed depending on where it is more easy to travel. A number of arrivals are in the Canary Islands now as well, to Spain. This is something that happened in the last years again, because of the Libyan, let's say, closing down the borders more and more. Morocco, of course, is also a transit country. You can find all the statistics. It will be in the PowerPoint as well, but you can find the statistics obviously everywhere. let's talk about the temporary protection quickly in the last 50 minutes, and then we have discussions. Because what basically I've talked about until now is the system that has been operated and sort of the political understanding how to approach asylum in the last, so from a legal point of view, but also from the practical point of view, with the hotspots approach, with the problem of externalization of borders, with the issue of I haven't talked about this much, secondary movements, etc., etc. Now, with the Ukrainian crisis, a very old, sometimes even called old dinosaur, or has been reacted. So I told you about the directive being from 2001 already. One of the first instruments have been enacted in asylum at the European level. This directive has been implemented as a directive for exactly this kind of situations like the Ukraine crisis. If you have you have a war, a lot of refugees going out of the country, there is an easy, unbureaucratic approach to provide assistance, and I come to it in a second how it looks like, to Ukrainian people. You could ask yourself, and this question has been asked by NGOs and activists quite a long time, why this directive has not been enacted when we had the situation in Libya, Libyan war in 2012. Actually, Italy at those time has asked to enact this directive. It hasn't been done. The same could have been said for 2015. There was a movement, a political movement. There was no agreement to open up the directive. You can ask yourself why. It might be because they are Syrians and not Ukrainians, and so that might be one of the reasons. I'm not going into it, but you can ask yourself what is the reason for it. Same could have been taken, and the same approach could have been taken, for example, when Taliban took over Afghanistan again. There was discussions about this as well, 2021, last year. Again, it was decided not to do so. So this directive was basically that for all occasions when it could have been enacted, when it should have been enacted, was not taken. And even in 2020, in September 2020, when the European Commission opened up a new proposal, sorry, for the European Migration and Asylum Pact, then it was even proposed by the European Commission to take this directive completely away and to replace it by a new one, which would be then a real tool possible in some circumstances, because it was considered to be non-useful, non-practically implementable, because politically never wished. Then the Ukrainian crisis came up, a close country to Europe, all Christians. Maybe that's one reason. Of course, all this kind of situation where we all feel very close to Ukrainians rather than to others, and a bit ironic here. But of course, this has helped to enact this temporary protection scheme. But it has to be said as well, the situation was quite sort of unexpected, but at least you could see that it was clear that the Russian invasion to Ukraine would have clearly created a big refugee crisis in Europe. So what has been enacted was the directive of 2001 about the protection, temporary protection of the space. I'm putting here slides which actually used by the European, I think it's the European Commission has been enacted them. I think they're working quite well, but I will highlight some of the criticalities which are a bit left out on this kind of slide. but I thought that might be quite useful for getting an overview. So it has been enacted in a decision by the 4th of March, quite quickly after the 24th of February, when the invasion was. So it's really in two weeks, a decision has been done to enact this directive. You have to know that the directive has been implemented into national law by all the different countries since 2002, and some other countries who came later, like Romania in 2007-8. So this directive has been there, but in order to make this applicable, you had to have a Council of the European Union, so member states, decision to enact the directive. So it's sort of sleeping there, and as soon as they decide yes, with a majority, absolute majority, then the directive would apply. And then immediately the framework, which has been already implemented in national law, is immediately applicable. That's what happened in March 2022 this year. Okay, so quickly on numbers, and that shows you how important it was actually to open up, because you're talking about a high number of people. Now you have some differences here, 7.7 millions of refugees crossed the border, and only 4.3 have actually been registered as temporary protected persons. The difference comes from 2 points. One is not all have requested the temporary protection. Some are in Russia. A lot of actually are in Russia. 2.8 million are in Russia as refugees. May sound a bit strange, but a lot of those are in this area, of course, also Russian descent, so it might be easier for them to get protection in Russia. And of course, not all registrations are already done, so a number of registration problematics are still there. As you can see here, most of them are in the countries that are closer to the conflict. Poland in first place. Poland, for two reasons. One is, of course, neighboring country to Ukraine, but also because Poland has since 2017, in May 2017, you have to know that the visa obligation for Ukrainians to the European Union, to the Schengen states, has been abolished. So Ukrainians could enter to the European Union since 2017 easily. That created a movement of a lot of workers from Ukraine to Poland, and there was a manpower need in Poland for a lot of infrastructure work, auto motorways and that kind of stuff. And Ukrainians have floated Poland already at those times. So a lot of those people very close to Poland, they can speak the same language, basically, they understand themselves quite easily. They're all close in terms of Christian beliefs. And so it worked quite well for the Ukrainians to go to Poland. And we're talking about already 1 million persons have worked in Poland beforehand already. Then the war broke out. And of course, it was logical that a lot of those people have already ties, either been in Poland beforehand, known already some Polish people, some friends have networks there, but also people that have been in Poland at those times, and family members came over to get refugee status. Protection in Poland. So this is one of the reasons why it is Poland is certainly the highest country, the country with the highest inflow of Ukrainians. You can see that the Czech Republic has received a lot of those persons too. Again, language-wise, the same situation. Czech, Polish, Ukrainian is quite close. But it's also it's closer to going back. And Germany. These are the three countries basically where people are mostly getting protection. Okay. So what is offered. Let me quickly go to the what is actually protection provided. So what's happening with the directive is that the directives open up a way to get automated protection. You don't have to claim individually that you have to prosecute, that you are facing prosecution or harm in your country. You just have to provide proof that you are an Ukrainian national and their family members are protected. All those who have resided in Ukraine before the 24th of February and then coming to Europe can in the country go and ask for temporary protection. So you just have to prove your nationality and your residence in Ukraine, and that's it. The same is true for all those people that are not Ukrainian and stateless, so have a protection in Ukraine. There have been quite a number of them, and so if you flee as a protected, as a beneficiary of international protection from Ukraine to the European Union, then you also get international and temporary protection. The same is true for those who have permanent resident status in Ukraine. It may also apply to people that live, Ukrainians who have not lived in before in the Ukraine. So people, for example, already working in Poland as an idea. Wait a second here. So people that, so Ukrainians basically also in a situation that have not been fleeing specifically, but cannot return. Now, it may also apply, and this is the may clause, it's a bit tricky here, is that also non-Ukrainian nationals, here the slide from the European Commission is a bit more controversial because it claims that non-Ukrainian nationals who are not permanent residents cannot be returned to the country of origin if the country of origin is unsafe. What this implies basically is if the country of origin is safe, the person get no protection and needs to leave the country of origin. So again, the discussion we had already, what is safe is something which is considered to be a questionable. Morgan's particular, you can also have questions about individual persecution. There has been one big issue, and you have heard about this potentially on the borders. Ukrainians have been floated without any problems crossing borders, and even before the war was the big issue came with the Poland closing the borders to Belarus, for example, in particular, to all those people crossing the borders irregularly, non-Ukrainians. So this is a big issue, and actually practice that has been a big issue. For example, in Ukraine, Ukraine was famous for foreign students. A lot of foreign students, more than 70,000, have studied in Ukraine. So foreign students coming from Africa, Morocco, for example, only from Morocco, I think we have had something like 4,000 or 5,000 students from Morocco. So the question was, what to do with those students fleeing the war, obviously like Ukrainians, but not in a position to get automatically access to protection. So in this case, you actually have to show other kind of ways to ask for protection in the country and not automatically receive the temporary protection. What is temporary protection including? You get a sort of permit to stay. The permit to stay gives you access to residence rights, access to labor market, and actually all this are different or deal differently in most of the countries than the refugee asylum procedure system. So you're not going through a hosting system sometimes it is mixed with the asylum procedure classically, but sometimes it's even not. So you have actually an easier way to get access to housing, to labor market, social welfare, healthcare, and all this kind of stuff. Children get education, all those kind of things. It is automatic, so it is you actually sometimes even sometimes you get just a sticker in your passport. Sometimes it is a residence permit that you ask for, and you get a real card. Sometimes it is, but it's automatic in a way that you just have to show that you're Ukrainian and you're eligible for protection, and you get it. It's not, there's no individual assessment. It is up to 1 year, and that's renewable up to 3 years. What is interesting is that, and this is something that was striking to me at least, the refugees, the temporary protection is actually, it's up to the Ukrainian or the person who's claiming for temporary protection to ask where you would like to take up the refugee protection or the temporary protection. It's not it's not the Dublin system, as we will see it on Tuesday, has not been enacted. So meaning it is freely chosen by the Ukrainians, for example, to which country they would like to go. This is something which has been debated by NGOs strongly, has been claimed and asked for after particularly the crisis of the European asylum system in 2015, to abolish this kind of Dublin system where you only have one single country where you can make your asylum application. Here it is really up to the request, the person who is requiring temporary protection to ask those states who would like to which the country the person would like to go. So it's a pick and choose kind of thing. And you have seen a lot of those persons have chosen to go to countries which are close to the border to Ukraine because of the fact they claim they want to go back. They go back, by the way, from time to time, depending on also on the situation. Okay, and they can obviously also travel. So it's this free movement in the European Union. It's quite striking. It's always been a problem in the normal refugee field, but here it's opened up and it shows some possibility. If it's working not badly, that potentially countries may agree on this. I'm not so optimistic on this, but it's at least that could be a sign of hope that the Dublin system at some point get cancelled. But it's important also to say that you can also ask for refugee status. So you're receiving a temporary protection system regime, so you're protected and you can live and work and so on. You ask yourself, why would that make sense? Actually, it may make sense because as you have seen before, it is just a 1 year permission to stay, which is renewable. But with refugee status, once you get refugee status, you actually get, in some countries, even a 5 years protection. So it's much more stable if you get the protection. So beneficiaries might ask for a refugee status if the idea is to rather stabilize yourself further in the country. So I think I have done my part. Having a number of 15 minutes, I think, more or less.
Yeah.
Further discussions.
We didn't do the pause, so probably we'll respond with some question and we can leave early in case. Okay.
So where to start?
We have Bakri Erkam. They made a question.
Yeah. So
okay.
what are the thinking about Ukraine asylum system? Okay, we talked about this right now. It's a difference between, yeah. So it's clearly different, as you have seen. So it's parallel. You have really to imagine it's parallel, and actually, it is also meant to be parallel, because the temporary protection system has been built up in a way that it would not overload the normal asylum system. That's the idea, basically. You have a normal asylum system functioning, but as soon as you have a big inflow coming from a crisis like the Ukraine crisis, where a lot of refugees will come, you want to keep the asylum system working, while at the same time you open up a completely unbureaucratic, pragmatic approach to provide some protection to the crisis, the persons fleeing from a certain crisis. That's why it's completely parallel. Okay. I hope that's answered your question. So do you see, Kylie, do you see any hope in a recast of the reception condition directive in light of the new pact? Asylum Greece obviously is opening new reception centers funded entirely by the EU, but entrance and exit are biometrically tracked, and is considerably dignified. Yeah. So I think you have to. Differentiate asylum reception system, where I would. I'm not 100%, knowledgeable about the asylum reception system in Greece. I know that they are very questionable, they're overcrowded and things like this. But I think there should not be closed centers. There should be not controlled by biometrics, track systems, and things like this. What is different is the hotspots, and I think maybe you can clarify if I'm right what you're thinking. But I think you mean the hotspots by this. By your question. And I think the hotspot is a different question, because these centers have been built up by EU money, basically, and are completely, considered to be more or less closed centers. I think here the situation is highly problematic, because I do think that the implementation of the new pact, I don't have hope that this will disappear, this system. The hotspots specifically, and this border procedure proposal is actually considered to be one of the cornerstones of the system. You build up detention centers basically on the external border, where you have a medical control, but also an identification control taking place. And as we know, this is problematic, because people are not, as claimed to be, just for some days detained. They are often detained much longer, because the process is taking long, and so on and so on. So I think maybe you can clarify if I'm wrong, but in the hotspot system, I don't have any hope that it will be taken away. About the reception system in Europe, of course, thing has to improve. That's for sure, especially in Greece, but also in Italy. In Spain, reception conditions are not ideal, especially if you force people to take reception in the asylum procedure period. So what you have to imagine is that as soon as you take an asylum procedure and you ask asylum in a country, and your asylum request has been accepted, you formalize your asylum procedure, then you are forced to stay in a reception center, because countries want to track hold of you in the procedure. And of course, it's a different story if you just go for some weeks in such a center, and as soon as it's finalized, actually you can go by your own to other countries. Not other countries. Sorry, that's wrong. You cannot go to other countries, but you other places in the country. You can take a walk somewhere, work somewhere, and you can then find apartments and whatever. But this is problematic if you have to stay longer in these reception centers. That's for sure. So I don't know if Kalini answered your question. Can the classification? Sorry.
No, it was the same question. Some people asked that hotspot can be considered as discrimination.
Right. Yeah,
but it was
absolutely.
more than one question. So
yeah, right. Hotspots are, from my understanding, a very bad. And we're talking about, to be very honest, we're talking about problems for those areas where hotspots are. I mean, let's take Lampedusa, let's take Samos, let's say, I mean, we are forcing people on these islands or in these centers, often in very touristic areas, to stay in a closed center, oft overcrowded, obviously, exposed to discriminations and things like this. I cannot imagine how actually this would work well. So I think there are much smarter ways how you can actually enact this kind of thing in a much more smarter way. But this is it's also part of the policy of the European Union to show that we're not welcoming people. They want to show a reception in these hotspots, which are rude, problematic, because that might people say, "Ooh, I don't go to Europe anymore." I think that's part of it. Okay, Kylie has another question. You should actually talk. I'm sorry. Can you maybe raise your questions and your points, because you have a lot of things to say. Maybe you just open. Can we do this like this? Because I think it's, and then we can have more discussion rather than I'm responding to you, because I have the impression that you could have more to say than just
yeah, I opened the audio for Kyle so he can speak.
Hey, can you hear me?
Yes.
Yeah.
Hey, great. So yeah, this next question was specific to the events that took place yesterday. I don't know if you saw, but Malta had obviously violated Article 33 by asking expressly on the instruction of the Reception Coordination Center of Malta, a merchant ship in their territorial waters, to carry a boat of asylum seekers back to Egypt. And so obviously we just saw Frontex losing, or we saw them losing their 2020 budget in the most recent plenary session. So my question was, what kind of retribution is going to meaningfully change the behaviors of places like Malta and to some extent, Greece and Italy, when they see any sort of penalty that the EU has trotted out thus far as just being the cost of doing business?
Yeah, that's a very good question. Yeah, no, I have seen this, and this is just another sort of incident of a number of incidents that happened in the last years. Malta has always been very problematic in this area. So yeah, you posed the finger of one of those problems. I think one of the big issue is that if we are not turning European policy into a much more positive approach, I don't think that the countries themselves would put their attitude into more positive approaches. I mean, Italy has happened this. It has happened like this in 2013 with the Mare Nostrum system. It was a very small moment of history where this happened. Now, Italian governments, whether right wing or left wing, by the way, it doesn't matter, or center, whatever this was, unfortunately, was not even close to Mare Nostrum kind of approach again. And this was, I don't know what the reason exactly is, but I have the impression that there's this sort of feeling that even by left-wing governments, that as soon as you open up this kind of discussions where on a, let's say, more public place about migration, then immediately the problematic is that right-wing government parties will win, and they fear before they actually do anything meaningful. They fear already the consequences on political, and so they self-censor themselves, not doing something like this. I have and then there's the thing which is which gives. I mean, I'm talking to you in a way that I'm desperate in a certain sense, right? We have seen this government, which was a huge coalition about right, and I don't know actually what it was as a government, but the Draghi government in Italy, and actually. You have to know that the hotspots have been actually never been as harshly detention centers as in this moment at the moment. So it's under this government basically. So yeah, that shows you I'm very desperate in this sense. What would it change? I don't know. I mean, I think the European Parliament doing a great job, but in the end, these issues, unfortunately, are discussed and decided not by the European Parliament. And Frontex just signed another agreement with. I mean, budget is a big issue, obviously, but we will see how this turns up. But I cannot imagine that they don't find a way to get the budget approved somehow in a certain way for Frontex anyway. So because so many projects have been enacted already, contracts have been done, I can't actually see that this is. But that's a meaningful way to start, putting the finger in the problem. I'm not answering your question. I'm sorry, but this is far
No.
too
This is great. No, I hugely appreciate it. Thank you so much.
I think I think you put this in your comment now about the temporary protection directive. I do believe some of the elements that we see now with Ukraine implemented, like for example, I was struck by the fact that the Council of the European Union enormously agreed to open up free movement for Ukrainian refugees. I think this was striking to me. I would not have been expected this. It doesn't really work well for most countries, I would say, for all countries, because as you have seen in the numbers, I mean, basically you can find them in actually only 3 or 4 countries. They are not really spread around solidarity over the entire continent. So they are choosing those countries closer, where maybe you work better, but at least you don't have this kind of conflict where you have to bring those people to the first country of entrance or things like this. We talked about this on Tuesday. That's the nightmare in terms of logistics, but also in terms of costs. It's just not working. It's not really working at all. So I think that's something which potentially open up government minds if, as let's say, as a powerful government like the German government, you see anyway, you are doing the same as always. It is considered to be anyway a country where a lot of people come. You cannot do anything else. Just maybe that would open up some possibilities of discussions.
Yeah. Do you see that? Sorry, one really quick follow up. Do you see that then? I mean, as immigration lawyers and immigration attorneys, do you see that as a potential locus of strategic litigation against sort of the non-entry regime?
Yeah, legally speaking, it's problematic to use the temporary protection regime. That we mean?
To the fact that it had never historically obviously ever been used, and the entire purpose of the common European asylum system, and then Ukraine, now everybody's falling over themselves to make sure this works because of this universally reviled activity. But legally, it seems to open some doors that they may not have thought of, because obviously a lot of these places that are accepting Ukrainians their governments are very racist.
Right. But I don't think that's easy to make it as a basis for stratification. I do believe there are some grounded reasons why there is an openness to Ukrainians at the moment. There are some discussions, by the way, already. Czech government, for example, sees the public opinion turning into some problems with Ukrainians. So they started to think about limiting the access of Ukrainians already to different services, because there is a sort of momentum potentially. Potentially, I think it might turn into, if it's going longer like this, into a more severe system again. We have seen this, by the way, every time. If you look at what happened in 2015, same was there. There was a welcome impression, at least for some states, for some moments of history, and then governments closed down quite quickly because public opinion turned into some more problematic. Yeah, I don't know. I do see also the problematic of using it legally, because this system is so unusual. It's very pragmatic. It's very straightforward in terms of how to implement it. I think it's as I see, potentially we can use it, and we should use it in terms of more advocacy as a way to overcome this kind of very strongly bureaucratic asylum system at times. I think that's the way how to take it legally. I think I don't see a lot of approaches to use it in certification. But maybe I haven't really understood how to do it. Could be interesting to do it.
Thank
Awesome,
you, Kyle.
Can you say just how, because I potentially not pronounce your name correctly? Kylie or Kyle?
Kyle.
Kyle. Cool. Thanks
for your questions. I think we almost responded to all questions about Ukraine. If someone else has some other questions.
I think I see just one question from Bali saying is whether there is any sort of tampon zone for Ukrainian asylum like Turkey and Libya. I don't think so. I think it is because they are quite Ukraine, Poland are quite border countries. So I think that's not real. And especially it was also that Poland is the country where a lot of Ukrainians have explained why. I think they're not going to France because there's no tie with France. So I think that's the reason why it actually happened to be sort of the tampon zone for a lot of other countries, if you want, Poland. But at the same time, it's part of the European Union, so you cannot really say the same as Turkey and Libya. Okay, the same way of Lucia, excuse me.
If you want to respond to Daisy Brown, but I think most of your lessons responded about the crisis on Ukraine. So,
oh right, yeah, no crisis. I mean, again, I don't like the way refugee crisis is always defined. That's a problematic term in itself. That's potentially what you're meaning by this, and you're right to raise it as a problem. What I meant is that obviously that the asylum system in Europe would be in crisis, because that's the point. As soon as you have a lot of people coming, it puts the asylum system at a crash. If you have to wait for your individual assessment decision, which has to be taken by an individual interview, and a decision to be taken and delivered to the person, and then there's appeal, and all this kind of stuff takes you to a year's process. And especially if you have a lot of those people, then it's a long process. That's why I think it was clear from the start that this invasion would actually create a lot of refugees coming to the European Union, and the response was, trying to avoid that there is the European asylum system in a crisis. I hope I answered.